Diksha, please introduce yourself.
Sir, I come from Koraput. I have completed my primary education from Saraswati Shishu Vidya Mandir, Koraput. Then I have completed my plus two from Kalinga Bharati Residential College, Cuttack. Then I completed my LLB, Integrated Law from Utkal University. Now I am preparing for judiciary.
Okay. What are your subjects as optional subjects in judicial service examinations?
Yes, sir, law of crimes and personal law and law of property, that is transfer of property of limitation and specific relief.
Okay. What is the power of a second class judicial magistrate regarding sentence?
Sir, a judicial magistrate second class can only give punishment for 1 year and fine up to 5,000 rupees. It is given under the provision of CRPC.
Then what is the power of an assistant session judge in imposing sentence?
Sir, an assistant sessions judge can give punishment up to 7 years or more. Sir, I'm unable to recall 10 years or 7 years.
So far as fine?
Sir, there is no limit to the fine.
Then what is the power of a chief judicial magistrate? Sentencing power.
The chief judicial magistrate can give punishment up to 7 years and also give fine.
Can an executive magistrate record the confessional statement or statement to be witness as per section 164 of the CRPC?
Yes, sir. An executive magistrate can record a confession.
Suppose you are a judicial magistrate somewhere, a person, the police sent an accused for recording of his statement under section 164 of the CRPC. What will do?
Sir, first I have to warn that person who is giving the confession that it is up to him that if he wants to give the confession, then he can give it. If he doesn't want to give the confession, then it is okay. And I also warn him that after giving the confession, that confession can be used against him. And after that, I have to if that person will give me assent, then I'll start taking his confession or the statement.
Simply he agreed for this recording of his statement on section 164 CRPC. And you record it. You will record it. Is it not?
Pardon,
In
sir.
spite of in spite of warning, etc., he agreed, he consented for recording of his 164 statement, confessional statement. Whether both is to be administered to that accused while recording his confessional statement.
Sir, I'm not able to understand the question.
Oath. Do you know what is oath?
Yes, sir. Oh, but in this case, oath is need not to be taken.
Suppose you record the statement of a witness under section 164 of the CRPC. Whether you will administer oath to that witness or not.
Sir, in this context, I think oath need not be taken.
What is the warrant case?
Um, um, Sir, I'm unable to recall the provision. No.
What is the arrest? What do you mean by arrest?
When a
How
person,
arrest is to made?
sir, arrest can be made by any person, by a police officer or by any other person, normal person and can also be made by a magistrate. Arrest means to detain a person or restrict that person from moving uh, from any direction. Arrest is not like that to keep a person inside a room or anything, but simply to restrain that person. And arrest can be made by police officer, a magistrate, or by any other normal person.
Whether handcuffing is to be done at the time of arrest.
No, sir, handcuffing cannot be done. It is only can be done when the person when the person who is to be arrested resisting the arrest, or showing anything to the person arresting, or resisting, simply resisting.
What are the additional grounds available for the a wife to claim for divorce, to file application for divorce?
Sir, if the husband is involved in bigamy, or the husband is uh, involved in uh, the, if the husband does not give her maintenance, or the husband is involved in bigamy, then the wife can um apply for divorce.
What is divorce by mutual consent?
The divorce by mutual consent is given under section 13B of the Hindu Marriage Act, when both the parties to the marriage to consenting to over their marriage, or they want to stay separate from each other, then they can apply to the district court or the family court to uh, to dissent their marriage. And here both the parties to be the consenting parties. The ground should be irretrievable breakdown, or that both the parties want different things from their marriage, so they can ask for the judicial assistance to over their marriage.
What is co-personal property?
So co-personary property is also known as ancestral property, which can be passed on to one generation to another generation of the family.
A woman married on a particular day. Prior to that, he had succeeded some property from his father. His father was dead. He succeeded a very palatable, that is a big building in Cuttack. She got married. Soon after marriage, she was going to her in-laws' house with her husband. There was an accident. The woman died. Then the husband claimed that property. Will you get that property?
Sir, she got that property from her father. So, if she died intestate, then the property should go to the heirs of her father and not to her husband. It is given under section 15 of the Hindu Succession Act.
Who is a Can you give an example of class one heir?
Sir, section 8 of the Hindu Succession Act talks about the class 1 heir. Class 1 heir is of 16 numbers. Sir, can I give all the examples, all the 16 numbers?
No, any one or two.
The son,
Give
daughter,
two
widow,
examples.
mother of the intestate.
What is estoppel?
The Restopol means it is a doctrine. When one person says something, then and when he gives that statement, then afterwards he is not he cannot able to negativate his own statement. He have once he gives his statement, he have to stood by it. So doctrine of estoppel restrains a person when he does not want to do the things which he have already said or done.
What is dying declaration?
The dying declaration is a statement which a person gives when he, sir, I'm unable to explain it. It is given under section 32 of the Indian Evidence Act. when a person thinks he is going to die and he gives any statement about his death or about his injuries, which he thinks that for that he is going to die, that is called dying declaration.
Suppose that person did not die. After that, whether the declaration will be used as evidence.
Yes, sir, it is used as evidence, but not as dying declaration. It is used as a corroborative evidence under Section 157 of the Indian Evidence Act.
What is mortgage?
Sir, mortgage is a mortgage is defined under Section 58 of the Transfer of Property Act. Um, uh, uh, it is something uh, through which a mortgager can take some money from the mortgagee, and by giving in return. Sir, I'm unable to explain it. I'm unable to recall the definition now. Sorry, sir.
What is lease?
Sir, lease is a right of enjoyment which the lessor gives to the lessee for a specified period for some consideration. That consideration can be money, share of crops, or any kind of premium. When the lump sum amount is given, that is called premium, and when the rent is when some meager amount is given, that is called rent. Lease can be of two kinds: it can be given on the basis of year to year and can be given on the basis of month to month. The properties which are given for agricultural purposes and manufacturing purposes, that is called year to year lease, and the other kind of leases are month to month lease.
What is tenant holding over?
Um, when the tenant is leaving, when a person is taking a property on lease, and after the completion of the lease period he is still living on that place or on that property with the consent of the person or consent of the owner, then that is called tenancy by will or tenancy by holding over.
What is vested interest?
The vested interest is given under Section 21 of the Transfer of Property Act. um, Sir, I'm unable to recall the definition. Sorry.
I don't want definition. What is your concept?
That means a interest which is absolutely vested on a person. Sorry, sir, I'm unable to explain it.
Okay.
I'll go
Okay.
through it.
Okay.
Sorry, sir.
Who is a mutawali?
Sir, Mutabali is a caretaker of the Waqf property. When a property is given or submitted to Allah or submitted to the uh, mosque, then the property should be in the care of some person, and the person who takes care of that Waqf property is called Mutabali.
What is khulla divorce? Khulla talak?
Um, Sir, Khulla can be given by the wife. So it is kind of mutual divorce. Uh, I'm unable to recall it. I'll go through it.
When the magistrate can issue a search warrant?
So search warrant can be issued to search a person or also search property. Um, so when I'm not unable to recall the section.
What is the difference between abduction and kidnapping?
Sir, kidnapping is done only upon the children who are minor, but abduction can be done in any person. Kidnapping can be done in two ways, and kidnapping is done when the child is taken away from the care of the person in whose care he is there. But abduction is something where the person can be taken to any place by enticing. The provision of kidnapping is given under Section 359 and 360 of the Indian Penal Code, and the provision of abduction is given under Section 361 of the Indian Penal Code.
Can an unmarried girl adopt a child?
Pardon, sir. Can you repeat the question,
An
please?
unmarried girl can she adopt a child?
Yes, sir. An unmarried girl can adopt a child, but the only condition is that the if the child is a boy, then the age difference between the girl and the adopted boy must be 21 years.
Ex an unmarried woman is serving in a particular hospital as a nurse. A female child was abandoned by her mother, and the nurse brought that child and adopted child. Can she adopt?
Mm,
And if so,
mm.
what it should do?
So that child is abandoned, then
It's a
she
Hindu child.
okay, sir.
The abandoned child was a Hindu child.
Okay. Um, Sir, I'm unable to answer it. I I don't know the provision regarding this.
Okay. Let us the interview be made by this second panelist. Then thereafter I will give you the feedback.
Thank you, sir.
Okay.
Diksha,
Yes, sir.
please tell me what do you understand by the term cognizance?
Sir, when a magistrate utilizes his judicial mind and process the procedure of a criminal case by looking into all the materials given to him by the police officer, that is called cognizance, and it is given under section 190 of the Code of Criminal Procedure Act.
Okay. Uh, can discharge be filed in a summons case? Petition for discharge.
Sir, I'm unable to answer it.
Okay. Whether a bail which is granted by a police officer can be cancelled by a magistrate.
No, sir. A bail granted by a police officer cannot be cancelled by a normal magistrate. It can be cancelled by a sessions court.
Right. Yes. What do you understand by further investigation, and how is it different from re-investigation?
Sir, further investigation means to proceed the investigation where it is en- uh, ended, or uh, further investigation. In further investigation, sorry, sir. Further investigation needed to collect some more evidence or more things about the concerned crime. But re-investigation means when the investigation started from the beginning or in a new way.
Okay. What is the difference between wrongful restraint and wrongful confinement?
So wrongful restraint is given under section 339 of the Indian Penal Code, and wrongful restraint is given under section 339, and wrongful confinement is given under section 341 of the Indian Penal Code. Sir, in wrongful restraint, a person is restricted from moving in a certain direction, but in wrongful confinement, a person is restricted from everywhere, that he cannot proceed a circumscribing limit. Um, that's all.
How do you prove handwriting of a person?
Sir, it can be proved by a expert, and the provision is given under section 45 of the Indian Evidence Act. To prove handwriting, the opinion of the experts can be taken who had some expertise in that matter.
Okay. What do you understand by McNaughton's rule?
The McNaughton rule is related to the section 84 of the Indian Penal Code. It based on the insanity principle. When a person is unsound, then and has committed any offense, then he can take the defense of insanity.
Okay.
And it is under the general principle, general exceptions to the Indian. It is given under the general exceptions of the Indian Penal Code.
Yeah. What is the limit of solitary confinement given under IPC?
The total can be 3 months. It is given under section 73. And in section 74, in which method the solitary confinement can be given is defined.
And how is it to be given?
Sorry, sir, I'm unable to answer it. I'll go through it.
How do you differentiate between an attempt and a preparation?
Uh, Sorry, sir. Preparation is a stage where the person gathers all the things to commit an act, and attempt is a procedure where he starts committing the act. So, can I give an example?
Yes.
Suppose a woman is running towards a well for committing suicide, and some persons, nearby persons, stopped her. So it is in the preparatory stage. But once the woman jumped inside the well, it is called attempt. If she does not die, if she dies, then that is suicide.
Okay. So, uh, next question is, tell me, what do you think? Right to life includes right to die or not? What is the present legal position of it?
The right to life does not include right to die. Hmm. Sorry, sir. I'll go through it after this.
Okay. And what is the view of Supreme Court in triple talaq?
The triple talaq is unconstitutional as per the Saira Bano case, because triple talaq is something which which is very capricious towards the Muslim women, and it restricts the women to live freely. So it is unconstitutional, and it is violative of Article 21 and 19 of the Indian Constitution.
What do you understand by the vicarious liability?
So vicarious liability is something, if some offense is committed by one person, and he is employed by some other person, then the person who is employing the person committing the offense is also uh, liable. Means a master is liable for the act of the servant. So here the master is vicariously liable.
Whether specific performance of a part of contract is permissible.
So this provision is given under Section 12 of the Specific Relief Act. Part of specific performance is not applicable, but Section 12 gives an exception to it. When the small proportion of the contract is not performed, and the person who is not performing the contract agrees to give money for the part of the for the small proportion, then rest of the part can be specifically performed. And the second thing is, when the part which is not performed is a bigger part, and the person does not want to give compensation for that thing, in one case, and in other case he takes the compensation, but in both the cases specific performance cannot be done. So on the application of the other party, the court direct the party in default to perform the bigger part, and take the compensation and relinquish all his claims towards the contract.
What do you understand by doctrine of pith and substance?
Doctrine of Sorry, sir, I'm unable to answer it.
Okay. Um, what is the difference between prescribed period and period of limitation?
Okay. The prescribed period is something which is given in the act, and it also include the extension of the limitation period. And period of limitation is something, the main concern is whether the suit application or appeal is within the period or not.
Okay. Can you tell me what is an estate?
The estate is defined under section 29 of the Hindu Succession Act. When the property of a person, when the person dies intestate and there is no heir to him, no heir of him is alive, and then the property of him goes to the government, and here the property includes all the liabilities also.
Okay. What is the difference between custody and guardianship?
The custody means the person who takes care of the minor, or his sir, I'll go through it once. I am unable to differentiate it now.
Okay. What is the requisites of a valid adoption?
Um, so for valid adoption, the first condition must be there must not be a Hindu son, son's son, or Hindu daughter or daughter's son. For Means there should not be a son or daughter leaving, or means there should. Sorry, sir, I'm unable to explain it. But there should not be a son or son's son present before the adoption. Hindu son or son, and number two, the the person adopting must be a major and of sound mind. If a male is adopting, then he must take the consent of his wife. And there are some conditions where the consent of the wife should not be taken, where the wife has renounced the world or is unsound mind. uh, and in case of a female, when she is adopting, she must take the consent of his husband. And if her husband is unsound mind or has completely renounced the world or has converted, then the consent of the husband should not be taken. And before taking into adoption, the female should not have a son, a Hindu son or Hindu son's son. And once a person adopted a person, cannot again readopt that. Sorry, sir. I'm unable to explain it. I'll go through it again.
Okay. What is the doctrine of relation back?
The doctrine of relation back means once a person is taken into adoption, he or she should not have any kind of relation with the natural family of his or hers. But in doctrine of adoption, it says that uh, though the person is taken into adoption, but he cannot marry into that family where he is born. As if he is in that family, and also the property which are vested in him in that family also uh, cannot be taken back or cannot be divested.
Okay. Okay. Thank you, Deeksha. We'll come back to you after the feedback sir gives.
Thank
Yes. Diksha, your introduction was lengthy. Try to minimize it. I am from South Answer. Yes. I've studied up to this and I'm presently doing this. You are presently doing LLM or preparing for OJS examination?
Sir, preparing for judiciary.
No, I'm appearing in different competitive exams.
Okay.
You may see. Then, so for your answers are concerned, only your concept is how far you know, how far you understand the particular question. That is the interviewer ask this question to me. But his sentence, you say 1 year. 1 year and fine up to 5,000. 1 year of either rigorous, yes, either in term, either time. Astral sessions, that is 10 years and fine. Chief Judicial Magistrate, 7 years and fine. Executive Magistrate cannot record the 162 statement. Only Judicial Magistrate will record in 162 statement. Then before recording one statement, confessional statement of the accused, some precautions. You will disclose your identity to him. You will inform him that he was not bound to confess. If he will confess, that will be used against him. Apart from that, you will put some question and satisfy yourself that his confession statement is voluntary. You have to record this by putting some question. The magistrate is satisfied that his statement is voluntarily giving his confession statement. Then only will record. As because he consents, that is not enough. The magistrate is also required to inquire whether his confessional statement is voluntary. You may put a why you are confessing. What is the reason for your confessing? If he says that I am repenting my guilty, for that I am confessing, that is that. Oath is even for recording statement of a witness on section 164 of the CRPC, oath is to be administered. But for confessional statement, no oath is. Warrant case, it has been defined. Should not exceeding 2 years punishment. A warrant case, and here punishable that someone which is someone's case which is not a warrant case. Arrest, taking a person into custody is called arrest. You told it also. It's arrest. Police can make. Magistrate in his presence, a particular offence is committed. That is the similarly a private person can arrest in his presence a cognizable and non-bailable offence is committed. He can arrest. Handcuffing is not permitted because while resisting arrest, that is handcuffing will not be done. Only when there is escaping tendency of the accused after arrest, then the police may, with proper reason, may handcuff and by taking order. Thereafter, he will take order from the magistrate to handcuff the accused. What are the additional ground for divorce to the woman? What I told? If prior to commencement of Hindu Marriage Act, he had a wife or he had married, that is ground. Then, if the husband is guilty of this rape, bestiality, sodomy, that is a ground. Then, husband also, after passing of decree for maintenance, after passing an order for maintenance, there is no resumption of cohabitation for 1 year. That's a ground for an additional ground. But for the woman to leave. Another ground is that if the marriage has been solemnized prior to attaining of 15 years, and whether marriage consummated or not, and within 18 years, the woman that is terminated the marriage, repudiated the marriage. On that ground, she can also file a petition for divorce. That is another ground. Divorce by mutual consent. If you do not understand the concept, what is that? When and husband wife, when they may file a petition for mutual divorce, divorce by mutual, when they are living separately for 1 year and more, and they are unable to live together, and they have mutually agreed to dissolve their marriage by a three grounds. As they are separate living for 1 year and more, then they are unable to live together. and they have mutually agreed that their marriage be dissolved by decree of divorce. Then they can file a petition, divorce by mutual consent, and the court, after satisfy the truthfulness of that petition, if that is not withdrawn, then not earlier than 6 months and not later than 8 months, can pass a decree for divorce by mutual consent. Co-personal property, any property inherited by a person from his father, father's father, father. That is his co-personal. That is property. That is co-personal. As your answer is also correct now, because the property which has been inherited by that woman from her father, that will go to the heirs of, because in absence of child, the property is. Then estoppel. You also failed to answer. If a person by his act, declaration, and omission has made another person to believe a particular any fact to be true, believe a thing to be true, and on that belief, if that other person has acted upon, then in a suit between those two persons, he cannot deny the of that thing. That is called estoppel. If a person by his act, declaration, or omission has made a person believe something to be true, that then thereafter in a suit will only in civil case. He cannot deny the truth of this. Dying declaration. Any statement given by a person regarding the cause of his death or any of the transaction of the circumstances leading to his death, then that is admissible in evidence when the death of that person is in question in any proceeding. That is called dying. Mortgage, you also failed. Mortgage is a transfer of an interest, only one interest, a security for payment of money, an immovable property. Mortgage is the transfer of an interest in specific immovable property, a security for payment of money. Lease is a transfer of right to another to enjoy that property for certain period in lieu of payment of rent or periodical payment. That is this. Understood? Then tenant holding over means after termination of lease, if the tenant remains in the possession of that lease and the holder, this lessor accepts that, then he becomes a tenant holding. Tenant holding. Vested interest means what? Any interest which is created in favor of a person which will take effect forthwith or without specifying any time when it will take effect, or on the happening of an event which must happen, then that interest is called vested interest. Mutawali, manager of a work of property is called Mutawali. Mutawali is a manager of the work of Khulla. Khulla is a form of divorce that is not by mutual consent. Here in Khulla, the Mohammedan wife, gives offer to the husband to give her divorce, and she will surrender for divorce. Then that is Khulla. That is Khulla. Search warrant. Search warrant can be issued for production of document. That is there by the magistrate for production of anything, or similarly for production of a person who is detained, has been confined. In such case, search warrant. Then abduction, kidnapping not only for minor, kidnapping minor, innocent person, idiot, from the lawful guardianship of that person without the consent of that. And apart from that, there is a kidnapping from India. Whoever takes or entices any person beyond India, that is also kidnapping from India. Kidnapping are two types. Then abduction, if a person by force or by deceitful means takes any person to another place, that is called abduction. Married Hindu gal, Hindu nurse, proceed for her Adoption, the permission of the court. It is with the permission of the court, she can, with the order of the court. As you try to understand and answer question, and your answer is that I think, excuse me, sir, I not this much way. When you doesn't know any particular, you do not know a particular answer, you may say, excuse me, I don't know. Okay, thank you.
Yes.
Diksha, I also believe that the conceptual clarity is there, but reproduction of the answers can be a little better. Okay, so for that, yes, you have improved from the previous interview, but yes, some more action is needed to be done for you to be able to answer everything perfectly. So revise at least twice more all the core subjects, and you'll be good to go. Some questions that he could not answer. Right to die. Right to die is included within right to life now. Common cause versus Union of India. In this case, it has been held. Passive euthanasia, active euthanasia is not permitted, but passive euthanasia is permitted. Okay. Next is yes, wrongful restraint, wrongful confinement. To some extent, you said. Uh, and what else I asked? I asked
The doctrine
about.
of peace and substance, I couldn't able to
Yes,
understand.
doctrine of pith and substance. Doctrine of pith and substance, you did not answer. Doctrine of pith and substance means that first pith means pith means the whatever it the principle says, and the substance means that you look behind it. So doctrine of pith and substance means uh, the real matter that is challenged and not the incidental effect thereof. Okay, that is to be looked into. So that has been you please read about it, and you'll be getting about it. Okay, another question is custody and guardianship. Custody is the physical control, whereas guardianship is broader. Guardianship might not be having physical control, but then still then he'll be legally, if it legally he is having the control, then in that case that is called guardianship. That is different from custody. Eschat, you said it. Solitary confinement, yes, you said it, but the manner in which it has to be given, 14
I
days first, 14 days, and then 7 days. There is this rule, so that you go through. Of discharge in a summons case, whether discharge can be done in a summons case. Yes, discharge application can be filed in a summons case, even though there is no provision of framing of charge mandatorily. Still, then Supreme Court has given that even though charge is not framed, the substance of the accusation is read over. That is it. That is in light of the framing of charge. That is like framing charge. Hence, filing of discharge is permitted in summons cases as well. Okay. Still, I have to say you seem to be in a little bit of hurry. So after the question is asked, you take a pause, you reflect on the answer, frame it, take a deep breath, take a pause, and then answer. Then the answer that you'll give will be better, and you'll not fumble or try to jumble things up. Okay. So you're on the right track. We are again meeting on 16th, 17th for your final interview, and I think
think
you
mine is
must be
on
ready by then.
18th,
18th, so we'll have it on
second
16th. Your
half.
16th will do.
Okay.
Okay, 16th
Okay.
will do, and hopefully you'll be ready by then.
Thank you.
Okay, thank you, Diksha. You may leave now.
Thank you.
Thank you.